Good morning. Thank you for joining Mayor Brown's Global Financial Markets teleconference series. Today's call is entitled Using Technology from Recent Loyalty Program Financing. My name is Bill Bunker, and I'm with Mayor Brown. First, a couple of housekeeping items. This call is being recorded, and we will email an audio link to all participants should you wish to listen to the teleconference again or forward it to a colleague. In addition, the recording will also be available as a podcast on your preferred podcast platform. Since we will not have a Q&A session, please send your questions regarding today's topic by email to gfm@mayorbrown.com, and we will respond promptly. This is the same email address as is on your invitation. Today's speakers are Stuart Litwin, Gabriela Sakamoto, Jan Stewart, and Adam Wolk. Stuart is a partner in Mayor Brown's Chicago office and co-head of the structured finance practice. Stuart also co-heads Mayor Brown's capital markets practice. His experience has involved the securitization of virtually all asset types, and Stuart is one of the leading and most experienced lawyers in the United States in structuring, negotiating, and documenting U.S. and international asset-backed and other securities transactions, structured financings, and loan purchase transactions. Gabby is a partner in our Washington, D.C. office and a member of the banking and finance practice. Gabby's practice focuses on advising commercial banks, multilaterals, and other financial institutions on cross-border structured finance, capital markets, and acquisition financing transactions. She has particular experience with structuring future flow financing transactions involving the securitization of diversified payment rights and credit card merchant vouchers. Jan is a finance and securities partner in our Chicago office, whose practice is focused on structured finance, representing originators, investment banks, commercial banks, funds, asset-backed commercial paper conduits, and investors in the public and private markets. Jan has experience structuring complex financing transactions, including the securitization of various types of assets, such as solar loans and leases, credit card receivables, CLOs, and equipment receivables. Finally, Adam is a partner in the New York office and part of Mayor Brown's banking and finance practice. He focuses on leverage finance and advises financial institutions and other investors, as well as sponsors and borrowers in a variety of domestic and cross-border financing transactions. With those brief introductions out of the way, I will now turn the call over to Gabriela Sakamoto to begin today's discussion.
Hi. Hello to everyone on the call. I am going to begin by sort of giving an introduction to the recent loyalty program financing structures that have been seen in the market. And then I will pass it over to my colleagues to speak about specific elements of the transaction, as well as certain issues that may be faced by companies in thinking about or in doing these transactions. Now, since the start of the COVID pandemic, there have been two major U.S. airlines that have raised significant financing based or backed by their loyalty programs. United Airlines was the first to do so in June, raising around $6.9 billion through new bonds and loans backed by its Mileage Plus loyalty program. And more recently, and using a very similar financing structure, Delta raised around $9 billion on the basis of its SkyMiles program. Now, as I said, in today's presentation, we will be providing an overview of these financing structures developed and used in these recent transactions. And we don't think that these financing structures are limited or exclusive to the airline business, although they have been used recently just in that sector. We're going to discuss which companies may be best able to leverage or implement these kinds of financing structures, and as well as discuss certain challenges that companies may face in structuring a financing backed by a kind of loyalty program. I'm going to start by talking about some of the what I call key loyalty program assets that were part of these financings, as well, and then move to sort of discussing some key structural elements of the financing. Now, the key loyalty program assets that were used in the Delta and the United deal were the co-branding or partner contracts that made up the basis of these airlines' loyalty programs. And these represent a significant amount of cash flows for under these loyalty programs. And the type of co-branding or partner contracts that would be involved here oftentimes are with credit card companies that issue a credit card specifically branded by a loyalty program. But there are other partner contracts and agreements as well, for example, with hotels or car rental companies, and some of the major contracts are with these large companies, but some of them can be with smaller co-branding partners. Another key loyalty program asset would be the customer or member data that the airlines or the loyalty programs under these airlines have. And this is a huge database of its members, as well as history that these members have in terms of how they, for example, in a Mileage Plus or in the Delta SkyMiles program, how they redeem miles, where they travel, how they use the loyalty program. This is key kind of data about a very, very large database of customers, and that has some value for the company, of course, for marketing and selling information. The third key loyalty program asset is sort of the intellectual property of the loyalty program, and this would be typically the brand name of the loyalty program, the branding that is used with its co-branding partners, and as well as certain kinds of licenses or softwares that they might have with respect to the operation of the loyalty program. The co-branding or partner contracts represent significant cash flows for these companies, and these contracts would be something that they would want to leverage in any kind of financing. So airlines, for example, had previously been able to raise financing on more traditional types of assets, for example, airplanes or other kinds of spare parts or other assets more typically seen in financing for airlines. But the cash flows from these contracts were significant, and airlines were looking to find ways to leverage those cash flows to raise financing in sort of difficult times. So that is one reason why the airlines looked to these sort of loyalty programs. Now, in terms of the structural elements of the transaction, what is unique about these loyalty program financings is really that they employed kind of what we call a hybrid structure, using elements of sort of corporate financing as well as elements of securitization. And Stuart Litwin later on will sort of discuss why these were key elements and sort of unique, and also help the airlines raise capital in difficult times at good pricing. But the key structural elements here for the transactions is that there is a transfer or assignment of these loyalty program assets to a kind of bankruptcy remote vehicle in order to isolate those assets from the company. This is not a true sale in these financing structures, but they do implement these sort of features from securitization structures, and there is an attempt to ring fence these assets from the overall corporate parent as a whole. Now, once these assets were transferred to these bankruptcy remote vehicles, the key issue is to have the airline continue to operate its Mileage Plus program as it has with little disruption. And so once transferred, there is a series of structural elements to license back these assets to the company to continue for it to able to be running the program. And these kind of licensing back is a key feature because it's in virtue of being able to license back that creditors have an ability, right, to control the assets in the event of any kind of bankruptcy or any kind of default under the financing. So the companies have the benefit of the use of those assets, but the company at the same time has essentially transferred these assets to an entity, to a borrower, or that the creditors can foreclose upon and take advantage of and take those assets in the event of any kind of default. So I think one of the key assets that I mentioned are the co-branding or partner contracts, which represent these significant cash flows. And one of the challenges of these kind of financing structures is how to essentially assign or transfer these contracts and how to essentially have the benefit of the cash flows from these contracts in a secured financing. And on that, I'm going to turn to my colleague Jan Stewart, who is going to talk about some issues and challenges related to the loyalty program contracts.
Thanks, Gabby. In the transaction Gabby described, United valued its Mileage Plus loyalty program at over $20 billion and said it had more than 100 million members and more than 100 partners, calling the loyalty program an essential asset of the company. As Gabby mentioned, financing the assets and cash flow of an already established loyalty program with existing partners and partnership agreements that may have been executed years ago without such a financing in mind presents unique structuring challenges. Some of those items that should be considered when structuring this type of transaction include, number one, abiding by confidentiality restrictions. Number two, applying UCC principles to override restrictions on transfers in the partnership agreements. And number three, ensuring continued performance of existing contractual obligations. A bit of background information about one typical partnership in any loyalty program, the co-branded credit card, would be helpful to illustrate these challenges. In general, a co-branded card relies on a relationship between the issuing credit card company and the loyalty program operator. A consumer often decides to sign up for the credit card because they will receive valuable perks or benefits with the loyalty program operator for using that card. The credit card issuer benefits from the partnership by gaining access to the loyalty program operator's customer lists and enters into a marketing partnership with the loyalty program operator to develop incentives and promotions to increase the use of the credit cards. The loyalty program operator usually receives fees from the credit card company for this partnership, including origination bonuses for new consumers that the loyalty program operator brings to the credit card company, a percentage of the fees and interest the credit card company collects from consumers on the credit cards each month, and payment for the purchases of the perks or currency of the loyalty program. The loyalty program operator is responsible for fulfilling redemption of this currency from its loyalty members, but many of the points or currency go unused, making the purchase of such currency a valuable way to increase the company's cash flow. As you may have determined based on that background description, loyalty program partnerships are usually a competitive process, and the details of any partnership between the loyalty program operator and their partner are usually subject to strict prohibitions on disclosure to ensure that the partner's competitors do not undercut their economic package. Negotiating with a partner for conditions that would lift those confidentiality restrictions is one of the most important first steps in such a transaction. The ability to disclose information about a particular partnership should also be considered when determining the type of debt financing that can be achieved. Obligations to keep certain data confidential could be in conflict with an issuer's obligation under the securities laws to provide investors with disclosure that does not make any untrue statement of material fact or omit to state a material fact necessary in order to make the statements therein not misleading. Including statements about the loyalty program generally, including consolidated company cash flows, rather than any specific information about any one partner or partnership agreement may be one way to thread this information needle. The second challenge to overcome when looking at existing contracts for loyalty program financing is to consider what restrictions exist regarding assignment in the contract. Thankfully, the Uniform Commercial Code has provisions in sections 9406 and 9408 that under certain circumstances may override contractual restrictions on the assignment of payment rights under the contract. These provisions are somewhat complicated, and determining which override applies depends first on which UCC collateral category the payment obligation falls in, such as promissory notes, accounts, payment intangibles, or other general intangibles. And secondly, on whether the assignment is a sale or merely a security interest securing an obligation. The more robust override provision is in UCC Section 9406D and applies to sales of or security interest in accounts and security interest, but does not apply to sales of payment intangibles. Using this contractual override section even allows the assignee to enforce against the original obligor. By applying these override provisions, it may be possible to assign the loyalty program cash flows even if the program partnership agreements themselves restrict assignment. One word of caution, though, these UCC override provisions do not work to override other contractual restrictions that do not directly block assignment, even though they may have the practical effect of blocking such an assignment. For example, the confidentiality restrictions I just discussed would still be applicable, even if the UCC override was used. The final factor to consider when structuring the financing of an existing loyalty program is what continued obligations does a loyalty program operator have in the partnership agreements. As mentioned in the typical description of a co-brand credit card program agreement, the relationship between the loyalty program operator and a credit card issuer is essentially a joint marketing arrangement. The loyalty program operator needs to perform certain marketing functions, such as offering the credit card and continuing to supply the customer data that Gabby mentioned, and most importantly, to continue to operate its business in order to receive the ongoing fees from the credit card issuer. Therefore, the partnership agreements may be considered to be executory contracts, meaning that there are still performance obligations outstanding. Upon a bankruptcy by any contract party, the debtor would have the right to decide whether to continue to perform its obligations under the contract or reject the contract and refuse to perform. In the transaction structure Gabby described, having a security interest over the intellectual property that is used to run the loyalty program was one of the ways the lenders intended to mitigate the risk that the partnership agreements would be rejected by a bankruptcy court. Stuart is now going to discuss how the structure of these financing arrangements may be used in a variety of other transactions.
Thanks a lot, Jan. So the real breakthrough is that rating agencies were willing to give an investment-grade rating for what is essentially corporate debt due to the structure of the transaction. Even with United guarantees, the rating agencies were willing to get to an investment-grade rating. So how did that happen? It happened because we were able to isolate key assets in special purpose entities from the bankruptcy risk of United generally. What was important was the inability for United to get at those assets without the SPEs themselves becoming debtors in a bankruptcy. So how did we do that? We structured those SPEs with independent directors. We made sure corporate formalities were observed, and we put in a number of other things that made it more difficult and less likely that those special purpose entities would become debtors in their own bankruptcies or substantively consolidated into a United bankruptcy. Probably the most important thing was that the rating agencies had to have a high level of comfort that even in a bankruptcy, these assets would be necessary for United to survive, and that United would be likely to honor the structure rather than try to disturb the structure. Because the rating agencies were willing to reach an investment-grade rating on the transaction, what we effectively have now are three categories of debt where we used to have two categories. We now have ordinary corporate debt. Number two, just like before, we continue to have true securitization debt. But now, number three, we have this third category of hybrid debt that's sort of securitization light. And that could potentially be used by other companies. So who could use a structure like this? Well, certainly the other airlines could use a structure like this. Also, other companies with loyalty programs could potentially use a structure like this. But here's the real amazing thing, is that now that rating agencies have achieved investment grade ratings for a hybrid structure like this, we have the potential that really almost any company that has the right kinds of assets could potentially achieve an investment grade rating and a bump up in their ratings, even if they're not investment grade. If you're a company that's already investment grade, the work, effort, and complexity of a structure like this probably isn't worth the effort. But if you're not investment grade or you're unrated, there may be some real value if you have the right kinds of assets. Now, the assets don't necessarily need to be receivables, and they don't even necessarily need to be assets that are throwing off cash. They could be intellectual property assets. They could be a manufacturing plant. They could be a particular customer or supplier relationship or multiple customer or supplier relationships. The critical thing is that the assets that you're trying to isolate are so material to the company that the company can't live without them, even in a bankruptcy, and can't be expected to reorganize in a bankruptcy unless it has access to those assets. And with that, I'm now going to turn it over to Adam Wolk.
Thanks, Stuart. So as Stuart and Gabby have mentioned, an important aspect of these deals is that they're really hybrid transactions where there are corporate finance concepts that are also involved in structuring these transactions. The United deal, which is also the case with the recent Delta transaction, both involved a parent guarantee from the parent company, which served a role in order to improve the credit and result in a higher credit profile for the credit, in addition to the structured aspects that others have discussed. This may not work for every deal. It depends a lot on the parent company's existing debt documentation and covenants and whether those documents and covenants would permit such a guarantee of this new debt. In the case of United and Delta, the companies benefited from having an investment-grade covenant structure in their existing bonds and credit facilities, which didn't prohibit such a guarantee. So as Stuart mentioned, a transaction like this may not be advantageous for an investment-grade company, but it sure can help to have an investment-grade covenant package in that company's existing debt documents. Whereas for a leveraged company, they may have tighter covenants that may make it more difficult, not necessarily impossible, but more difficult to structure a transaction of this type. So the result of having this parent guarantee is that you end up with a very hybrid covenant structure when putting together this transaction, which in terms of what the transaction documents will restrict. So the negotiation of it can be tough, although these transactions now, I think, provide a model for future transactions. So you may have some covenants that borrow from structured finance with things like independent directors and the SPVs, maintaining SPV-like aspects. And you also have corporate-type covenants that give the business the flexibility to run the business. Certainly when you're having covenants that restrict a parent company and its subsidiaries, those companies need the type of flexibility that you would see in a corporate or leveraged covenant structure. These transactions is a bit extra complicated since the airlines, as I mentioned, they benefited from investment-grade covenant structures, but may not quite be investment-grade today. So coming up with a covenant package that works for a company like this, it could be a difficult negotiation. But again, these transactions now are a model for how other deals might work. There are other aspects of a deal like this where the ability to make that aspect of the transaction, that structural feature work, depends in part on restrictions in the company's existing debt documents. For instance, in a leveraged deal, whether it's a leveraged loan or a high-yield bond, there are typically restrictions on a company's ability to transfer assets to a subsidiary if that subsidiary is not also a guarantor of that existing debt. As was mentioned, these transactions involved transferring intellectual property and the co-branding agreements to a subsidiary. And a subsidiary, it's kind of important to this structure, very important to the structure, that subsidiary that takes ownership of the IP and becomes party to the co-branding agreements doesn't guarantee the company's existing debt. So in terms of how to do that under a company's existing debt documents, one way companies sometimes transfer assets is by using unrestricted subsidiary provisions. For those who aren't familiar with them, a company under their debt documents can designate unrestricted subsidiaries, which are not subject to the covenants, but are in a sense treated as outside parties. So there are limitations on transactions between the borrower and guarantors in those unrestricted subsidiaries, whereas transactions among the borrower and its restricted subsidiaries are more typically not limited. So to use an unrestricted subsidiary feature, the company would need to have capacity in their investment or asset sale baskets in order to move assets to those unrestricted subsidiaries. This could result in significant revenue-producing assets moving to that unrestricted subsidiary, which could have implications for the existing debt documents. For one, unrestricted subsidiaries don't count towards a company's EBITDA and therefore towards their leverage and coverage tests, which could be a problem for a company that needs the revenues from that asset to be part of their EBITDA calculation. Additionally, there's been a lot of focus by lenders the last few years on moving assets to unrestricted subsidiaries, which started, you might say, with the J. Crew transaction a few years ago with intellectual property moved to an unrestricted subsidiary. There's been increased interest in these types of transactions with more companies using a similar mechanic to move assets to an unrestricted subsidiary. And so lenders have been a lot more focused on moving assets, particularly intellectual property, to unrestricted subsidiaries the past couple of years. So it's better for a transaction like this if the assets could stay within the restricted group in a restricted subsidiary. So in the United deal, for instance, that the borrower Mileage Plus that took ownership of the intellectual property is a restricted subsidiary of United. And at the same time, it is also not required to guarantee United's existing debt. If the asset holding subsidiary is required to guarantee or pledge the assets to secure other debt besides this new debt that we're structuring, it defeats much of the purpose of this type of structure and can make it unworkable. That's about all I have. I'll toss it back to Bill to close it out.
Thank you, Adam, and thank you to our audience for tuning in. A few brief reminders. You will receive an email with a link to the recording of today's call, and the recording will also be available as a podcast wherever you find your podcasts generally. Lastly, as mentioned before, if you have any questions related to today's content, please email them to gfm@mayorbrown.com. Thank you again for your participation. You may now disconnect.